Welcome to Faith and Freedom. For the next few minutes, we hope to inform, inspire, and encourage you as we discuss legal victories and challenges to your fundamental freedom and religious liberties. Faith and Freedom comes to you from Liberty Counsel, a civil liberties education and legal defense organization. Join us now as Matt Staver, founder and chairman of Liberty Counsel, explains the latest legal issues all across this country. In the courtrooms of America, Liberty Counsel is winning the battle for your constitutional freedom.
The Court of Appeals has now cleared the way for our case to go to the United States Supreme Court as the next step. I am Matt Staver, founder and chairman of Liberty Counsel. Joining me is Harry Mihet, senior litigation counsel for Liberty Counsel. And Harry, this case, Liberty Counsel brought Liberty University versus Geithner against not only the Obamacare on behalf of employers, but also individuals. It's gone to the Court of Appeals once, then up to the U.S. Supreme Court. The Supreme Court ordered the Court of Appeals to rehear the case, argued it back at the Court of Appeals. Now we've got a decision. And the good news is, even though the court got it wrong on the merits, the court reached the merits, which means now we can at least have a ruling on the merits of the case and therefore ask the Supreme Court to review this case.
That's right, Matt. You know, there were other procedural issues in play here that the Court of Appeals could have decided and could have made it more difficult for us to get to the Supreme Court. Things such as the Anti-Injunction Act or the standing of the plaintiffs or the rightness of the case. All of those issues were decided in favor to us and to our clients, leaving only the merits discussion up for review at the Supreme Court now. And the Supreme Court likes those kinds of challenges.
Yeah, so, you know, the issue, if they had decided that they couldn't reach to the merits because of the Anti-Injunction Act, we'd have to have that go back up there, get to the Supreme Court, have them reverse it, come back down. We'd be another 2 years, maybe more. If they decided that there was no standing because the law is not going into effect right away, again, we'd have to go all the way up there just for that, come all the way back down and get to the merits. And that's what the Department of Justice wanted to do. The Department of Justice originally said the Anti-Injunction Act doesn't apply. And then that's the argument that they made all the way to the Supreme Court. But then when it comes back to our case, and our case is still alive and well and kicking, they said, oh, no, the Anti-Injunction Act does apply. And then they also said that we do have standing both for the employer and for the individuals to file suit. That all the way up to the Supreme Court was their position. Now it comes back after the Supreme Court. No, you don't have standing either for the individuals or for the employer. They really tried to sidestep this because they didn't want to get to the merits, and they lost on all of those arguments. The Court of Appeals ruled against them, ruled in our favor, and reached the merits.
Sure, and even when President Obama most recently announced that he would delay the effective date of the employer mandate by yet another year, the Justice Department wasted no time to file a supplemental pleading with our court saying that the case is not ripe. This will not go into effect until 2015, and there's no need to decide this issue now. Fortunately, the court rejected that argument and concluded that our case was ripe for a decision.
Yeah, what Obama wanted to do is clear the decks in many respects. Clear the decks, first of all, for 2014. He didn't want employers screaming about how this law was being implemented in time for the 2014 midterm elections. So that was very much a political, calculated decision. But also some of these other cases that have been going on with regards to the challenge to the HHS mandate have been going against the Obamacare law. And he wanted to clear the decks on that as well. Let's get them all off the decks. They're all moot because we're not going to implement it right away. Well, the good news is our case jumped over those hurdles. Now, that means we've got a ruling on the merits. And the court then reached the merits of the issues in this case. Now, our case, Liberty University versus Geithner, which is now Liberty University versus Lew, because Geithner has changed and Lew's in the place of him. But our case challenges the entire employer mandate, not just the abortion and contraceptive portion of the HHS mandate, but the entire employer mandate for secular and religious employers. And in that respect, it's unlike any other case that's out there in existence.
That's right. It really is the most comprehensive case of its kind, and now the most advanced case of its kind, and the one that would logically be the first one to reach the Supreme Court. So I think there is great reason for optimism in this development.
A very good reason for optimism there. And so consequently, we will be filing a petition to the United States Supreme Court. The Supreme Court comes back into session the first week in October. If they ultimately decide to take this case, we could argue it sometime perhaps even later this year or next year. and a decision would come down by June of 2014.
Sure, and it's the same court that, if it stays faithful to the principles of law that it announced in the first round of the ObamaCare case, it must come to the conclusion that the employer mandate and the entire law falls apart. There's no way that Congress does not have the Commerce Clause power to impose an individual mandate, but somehow it has that power to impose an employer mandate. It makes no sense.
Yeah, we argued here that the Supreme Court said Congress does not have the power under the Commerce Clause. The Commerce Clause is the clause that allows the federal government to regulate interstate commerce among the states. And the Supreme Court says Congress does not have the power under that constitutional provision to force individuals to buy an unwanted product. Well, if Congress doesn't have the authority to force individuals to buy an unwanted product, then how can it have authority to force employers to buy an unwanted product? And how can you say, well, Congress doesn't have authority under the individual mandate under the Commerce Clause, but, oh, by the way, they do under the employer mandate? It doesn't make sense. So then, of course, the next question is, but they did uphold the individual mandate as a tax. So how do you get around that? And our case presents an ideal situation for addressing that very issue.
Well, sure. The Supreme Court decided that it could be a lawful tax because it wasn't so large that it was punitive in nature or in character. And in that case, it was looking at a $3,000 a year?
$3,000 a year plus or so insurance premium. And now we know it may even be more than that, maybe up to $10,000 versus a penalty for not having insurance of under $100. Now it goes up to about a couple $100 over the years. But the penalty for not having insurance versus the premium for having insurance is significantly different. It's very small versus very large.
Right. But in any event, the court decided that that was not large enough to be punitive in nature.
Right.
Well, now when we're looking at the employer mandate, the penalty for not complying with the various strictures of Obamacare is in some instances $15,000 per employee per day.
Per day, and that's on top of the IRS because for employers, you've got a penalty for the IRS component, and that can be $2,000 to $3,000 per employee. And then you have the Department of Labor. And by the way, when's the last time the Department of Labor actually issued a tax? Another reason why this is not a tax. The Department of Labor does not tax people. We've never seen taxes from the Department of Labor. So here we've got the Department of Labor involved for employers, and you've got a $15,000 per employee per day fine. Tens and tens of millions of dollars. Now, somebody might say, well, and this is what the court said, but this employer is already voluntarily in the market. Well, the fact of the matter is the employer can't voluntarily leave the market because if they do, they get penalized. Mm-hmm. So if they want to not be in the market, they have this large penalty of $2,000 per employee. And if they're in the market, they have a large penalty that can even go up to $15,000 and even higher per day per employee.
That's right. And so under the Supreme Court's own logic and reasoning that has been handed down to us in the first round,
it can't be a tax.
There is no case, there's no way that this law can survive as a tax or as a commerce power.
So I think we've got a great case to take to the United States Supreme Court, and that's our next step. We had, in this particular situation, we had 3 judges, 2 appointees by President Obama, 1 appointee by President Clinton at the Fourth Circuit Court of Appeals in Richmond, Virginia. And so the next step is to ask the U.S. Supreme Court to get involved and take this case. And what we also know is that when the Supreme Court told the Court of Appeals to rehear a case, we had to have at least 5 justices that wanted that to happen, meaning that they're not done with Obamacare.
That's right. The final chapter on Obamacare has not yet been written, and it's our hope and our prayer that the second time around the court will finally get it right and will free Americans from this atrocity, this monstrosity that we've lived under for the last couple of years.
Well, we have an Amici book, basically as a friend of the court book, that we've listed. We got over 100,000 people around the country that have committed to praying for this case. And it's amazing to just take a look at this book and see people from all over the country, every state in the country, people all the way in Nome, Alaska, praying for this particular case. And your prayers certainly have made a difference, and we ask that you continue to pray for this case involving Obamacare. And also, I would encourage you to go to Liberty Counsel's website, lc.org, to learn more about this and many other cases and issues that we're involved with. Liberty Counsel is advancing religious liberties, the sanctity of human life and family through litigation, education, and public policy. And we need your prayers because we know that we're involved in a spiritual battle. And of course, these kinds of cases cost a significant amount of money, and we are supported by individuals just like you. You can go to lc.org to give an online credit card contribution. Our address is right there as well. You can mail in your contribution to Liberty Counsel or call 1-800-671-1776.
You have been listening to Faith and Freedom with Liberty Counsel. We hope that we have motivated you to stand up for your faith, family, and freedom. We can accomplish a lot when we work together. Get informed and get involved today. Sign up for our free monthly newsletter, The Liberator. We will send it out to you free of charge. Stay informed with our Liberty Alert email updates. Just click on the website at www.lc.org or call us at 1-800-671-1776. Tune in next time to learn more about your rights right here on Faith and Freedom.